The judge says to the defense lawyer, "Call your next witness, counselor." The attorney says, "Judge, I call Dr. Jones to the witness stand." I say, "Wait a second." I jump up, I yell, "Objection, Judge." I move to preclude this expert from testifying. You want to know what this is about and why it's so important for you to understand? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So this is a medical malpractice trial. And now the defense is ready to call a doctor to the witness stand to testify as an expert on their behalf. Why would I jump up out of my seat, yell out, "Objection, Judge"? This expert can't testify. I move to preclude him to prevent him from testifying. Why would I do that? Well, there could be a number of key reasons for that to happen. In one instance, the defense attorney might not have notified us that they were calling this medical expert in to testify. Now you might be thinking, wait a second, they don't have to notify us about which experts they're bringing in. Let me stop you there. Actually, they do. They have to notify me that they have retained a board-certified surgeon to come in and testify on their behalf. They have to tell me what this expert is going to be talking about. They have to tell me what opinions this expert will be discussing on the witness stand. And they have to tell me what this expert's medical credentials are, where they went to school, where they did their training, whether they're board certified, where they licensed to practice. That's a requirement before this expert can ever get up to testify. Now, what happens if the defense turns around and says, "Hey, Judge, we just learned about this expert. We just hired him the other day." Is that okay? The answer is, sometimes it is, and sometimes it isn't. Some judges will turn around and say, "Counselor, he notified you as soon as possible. He sent you out the information, the doctor's credentials, and what he'll be talking about just last night." "Judge, last night? I didn't have an opportunity to see this. I wasn't back in my office. I never got this information. So now I'm at a significant disadvantage to go ahead and cross-examine this witness. I'm not prepared for this." There's a number of things the judge can do in this instance. The judge can say, "Objection overruled," which means this witness can go ahead and testify. The judge can turn around and say, "Counselor, I'm going to give you 24 hours in which to prepare cross-examination. We'll bring the doctor back after he's questioned by his attorney." Now, that's not an ideal scenario for me. Why? Because now the jury is going to be sitting on this information that's coming in against us for 24 hours. I don't want that to happen. I would prefer not to have the jury sit on this. Is it enough for me to try and go ahead and off the cuff cross-examine him? The answer is I may have to, but it's not the ideal situation. Now, there are some instances where a judge will turn around and punish the defense lawyer for waiting till the very last minute to notify me that they're bringing in this medical expert. And they can sanction them with a monetary penalty, could be in the thousands and thousands of dollars. Now, as a very extreme measure, the judge can sometimes turn around and say, "No, I agree with Mr. Oginski. This witness is precluded from testifying," which means your expert is not going to be allowed to testify because you did not follow the discovery rules requiring you to go ahead and notify your adversary of which experts you were going to bring into trial. And because you didn't follow the rules, this expert cannot testify. So why do I share this quick information with you? I share it with you because this happens in every single case that comes up where the defense told. So why do I share this great information with you? I share it with you because this happens on a regular basis, especially in medical malpractice cases, in car accident cases, where the defense springs an expert on us at the very last minute, and now we may not be prepared to cross-examine that witness. You know, I realize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.